everyone. My name is Alyson White Eagle. I'm a member of the Northern Arapaho tribe and a tribal water legal fellow at the Native American Rights Fund under the newly created Tribal Water Institute. It is a privilege today to be joined by Professor Jason Robison, the Carl M. Williams Professor of Law and Social Responsibility at the University of Wyoming, the co-director of the Gina Guy Center for Land and Water Law, an adjunct professor at the Hobbs School of Environmental and Natural Resources, leadership team member of the Water and Tribes Initiative, as well as my former water law professor. Professor Robison is widely recognized as a leading authority on the law of the river, as the editor of Cornerstone at the Confluence and his role with the Water and Tribes Initiative. His work is contributing to the dialogue around the 2026 Colorado River negotiations. Furthermore, Professor Robison is known for centering tribal voices and equitable governance in his research, including his recent work in the Yale Law Journal on beyond binary co-sovereignty and his leadership within the Colorado River Basin. He works to ensure that water law is more inclusive. Thank you for being with us today, Professor. This interview is for the Headwaters Report, which is an online newsletter for tribal water information, which is a resource that was created by the Tribal Water Institute and meant to be a resource for tribal water leaders and anybody interested in tribal water law to access for those purposes. And today I'd like to get started with this interview. First of all, thanking you again for your time and just pointing out that based on your work with the Water and Tribes Initiative, why is it that we can no longer discuss water security in the West without also discussing tribal sovereignty?
Let me start off in a good way too, if I may, by saying thanks for inviting me. There's so many other folks with whom you could speak, and the fact that you're interested in hearing what I have to say is a really big honor for me. I'm a big fan of NARF and what you're doing, so thank you. There are three types of co-sovereigns in the nation state that is called the United States. And for the longest time, the federal sovereign, of course, has been recognized. And so too have the state sovereigns been recognized. But I do not think either in popular consciousness or in more formal circles, legal and policy circles, that tribal sovereignty has been recognized to the same extent. And I think that challenge exists in the context of transboundary water law and policy and a lot of other areas. But to your question, I think that tribal co-sovereigns have been historically marginalized in water governance. And I think that's unjust, and that there needs to be a push towards inclusivity and a greater respect for tribal sovereignty. And I have further thoughts on all those threads, but that's just an initial response for consideration.
Yeah, thank you for that. That actually leads me into my first question, which focuses on your work, the Beyond Binary co-sovereignty. And there, I understood your work to mean that to move beyond the federal versus state way of doing things, it would mean treating tribal nations as a core part of how the Colorado River is managed. So as we look toward the 2026 negotiation deadline, which is fast approaching, is there a way to give tribes a seat at the table that's just as permanent as the states, rather than just inviting them to consult? What do you think that actually looks like in that room?
Great question. Let me say one thing at a national level first, and then another thing that's specific to the Colorado River Basin. The national level comment just reflects that beyond binary co-sovereignty was an effort, or is an effort, to try to analyze how tribal sovereigns historically have been treated across the West, in and adjacent to the West, with respect to interstate water compacts. Interstate water compacts are really important for co-sovereign relations over big Western rivers like the Colorado or the Rio Grande, et cetera. And beyond binary co-sovereignty is partially focused on the Colorado River Basin, but it was broader than that. the takeaway really is what I alluded to a minute ago, which is that state sovereigns have been really visible when it comes to interstate water compacts. And the federal sovereign has been too, though to a lesser extent. That might be surprising, but tribal sovereigns have not been visible. If you look nationally at which sovereigns have a voice on the joint bodies, whether they're called compact commissions or otherwise, that are responsible for interstate water compacts, you'll see tribal sovereigns have no voice, like literally no representation. So what I have to say about the Colorado River Basin really is put into context by the attempt at a national perspective offered in Beyond Binary Co-Sovereignty. As far as the Colorado River Basin goes, you alluded to this, but I've had the privilege of working with Daryl Vigil and Matt McKinney on the Water Tribes Initiative for a really long time, and a bunch of other colleagues too on that leadership team. And you're right, the issue with Colorado River governance, one of the many issues with Colorado River governance that has persisted for a long time, is tribal inclusion, or the lack thereof. And it's a huge problem in my view. The challenge is, if we're going to move towards true co-sovereignty and greater inclusion of tribal sovereigns, how do you build those institutions? What do they look like? How are they designed? And what I would say about that subject in the space of the Colorado River Basin is really twofold. One, I want to start with humility. I don't feel like it's for me to say as an individual. I feel like that subject is one that needs to be discussed openly and intelligently by the co-sovereigns, by the federal government, the states, and the tribes, right? That's the first thing. The second thing, having said that, I do have thoughts about what co-sovereignty and water governance might look like in the Colorado River Basin. And my biggest concern is just that the tribes wouldn't have adequate representation. That they either would be relegated to having the federal trustee represent them in some sort of formal capacity, or even if they were to have direct representatives on, say, some sort of joint body, the joint representatives would be of secondary status. They wouldn't have the same authority and power, et cetera, as representatives of the other sovereigns. Both of those concerns are very real to me. And I can say more about each of them. But the overall point is just that designing a governance body in the Colorado Basin that's inclusive of tribal sovereigns takes a lot of work and is going to involve a lot of dialogue. But in my view, it's absolutely necessary, even overdue.
Right, I agree. What would you say some of the biggest roadblocks to that are, considering that there are so many tribal nations in the basin?
Definitely. I think there are a couple things that are worth considering, and both of them in academic speak can be wrapped around the concept of path dependency, which is basically the idea you get used to doing things one way, and that just becomes the way and the status quo when everybody gets comfortable, for good or ill, with the status quo. So path dependency. There's kind of two things for me. One, we've never had a basin-wide governance entity for the Colorado River system, ever. Mm-hmm. In 1922, when the Colorado River Compact was negotiated, that idea was floated. Their tribes were completely excluded from those negotiations. There were no tribal representatives at the table when the Colorado River Compact was negotiated. It was purely a state-driven process with Herbert Hoover, then Secretary of Commerce, serving as the federal commissioner. That was the co-sovereign relationship or arrangement in the negotiation of the Colorado River Compact. But back to your question, as a result of those negotiations, no permanent basin-wide entity was ever built. They decided not to do it. And I could go into more detail about why and what the dialogue looked like among the commissioners, but I won't. The upshot is just that the Colorado River Compact put into place a basin-wide apportionment scheme in the United States for the Colorado system without a governance body, a formal governance body responsible for administering that apportionment. that is very different than how we think about transboundary water law and policy in 2025, more than a century later. So that's the first issue, is we've never had a full basin-wide governance body ever since the Colorado River Compact's negotiation in 1922. The second thing is, to the extent that Colorado River governance does occur, it's done informally in an ad hoc manner that's often very reactionary, particularly reactionary towards the impacts of climate change on the Colorado River system's flows, the hydrology, which have been, those impacts have been profound in the last quarter century. In those spaces where decision-making is occurring and has occurred over the past quarter century over the river system's governance, the general arrangement among the co-sovereigns is that the states have the primary role, the primary voice, and the primary seat. The federal government tends to facilitate. It can enter into the picture and even place rules in place if it needs to, but instead, the federal sovereign historically has been more deferential toward the states, and the tribes really have been on the sidelines. So the second thing is the roadblock, as you described it, is we have a system of governance where co-sovereignty has been balanced in a way that has been heavy towards the states and involves somewhat of a deferential posture by the federal government, and tribes have been much more along the margins.
Looking back at one comment you made earlier about the initial signing of the compact in 1922, what would you say are some strides that have been made in the last century when it comes to the inclusion of tribes?
Right. I guess one way to think about that is with respect to strides on tribal water rights and the recognition and quantification of tribal water rights. And another strand, another way to think about that would be decision-making and inclusion in these governance bodies, which is mostly what I've talked about so far. I'll say a little bit on both. There has been progress made with recognition and quantification of tribal water rights under the Winters Doctrine within the Colorado River Basin. There are 30 tribal sovereigns within the basin. My last count, I think there are still 11 that have unresolved tribal water rights claims. And that's 117 years after the U.S. Supreme Court handed down Winters. So think on that for a minute. About a third of the basin's tribal sovereigns still have outstanding, unresolved tribal water rights claims. And furthermore, having a tribal water right on paper is different than actually being able to utilize the water and to provide wet water to tribal communities. So they're not the same thing. Nonetheless, not to be, or to avoid to some extent pessimism or cynicism, we do have roughly 20 tribal sovereigns, probably just a bit more, who have had, through litigation, Arizona versus California, or negotiated settlements from Auction in 1978 to Hualapai, recently, I believe it was 2022, who've had reserve rights claims resolved. That's some progress. That is some progress. A long ways to go, but that is some progress. The other space is the governance space, and I can be quick about that. There have been opportunities for tribal engagement in decision-making over the Colorado River's management during the past quarter century, particularly over the past decade. The federal government and the states have been trying to create more spaces for dialogue involving tribes over the Colorado River's management. Having said that, it would be completely disingenuous to suggest that those opportunities for tribal engagement in decision-making over the Colorado River's management, that those opportunities are on parity with state sovereign engagement and federal sovereign engagement in Colorado River management. No way. But there have been efforts made, and that too, back to your question, is an illustration of progress.
Yeah. Thank you so much for that. I'd like to move into another article you've written, Relational River, Arizona v. Navajo Nation and the Colorado River. There you write about how the Colorado River isn't just a commodity, but rather a community of sovereigns. And I really like that. What I find relatable about that idea is that it moves the focus from water as property to water as partnership, which is something I think a lot of tribes can appreciate, because water is a shared resource. Water is something that is sacred to a lot of tribal nations. And in that article, you really highlight the relational duty the United States has to tribes to their trust responsibility. From a legal and administrative standpoint, what do you see as the most effective path for the federal government to fulfill that responsibility, specifically in helping the tribes bridge the gap between their legal water rights and the actual infrastructure needed for water security?
Great question, and a tough one to answer in a short period, but I will do my best. The first thing I'll say is not directly responsive, but I would be remiss not to comment on what you said about partnerships. The way I've come to think about this has really evolved as I've grown. For so long, I always thought water was remarkable because of how essential it is. The essentiality of water really makes it special. Everyone needs it, every form of life. We start life in water, it's described as the first medicine, completely understandably, right? So to put this differently, I've always thought water's essentiality was such a remarkable quality of it, Mm-hmm. But to your point about partnerships, as I've thought about this more, I think water is relationality. Water inherently puts all beings into relation because of its essentiality. Because water is so essential, it puts all of us in relationship. It makes all of us deal with one another. And by all of us, I mean all forms in Western science speak of biotic life and ecosystems, et cetera, or from more a spiritual perspective, all relations need water. That's so remarkable. Translating that into the law and policy space and the trust relationship, my thoughts there are twofold. I think Arizona versus Navajo Nation was wrongly decided with respect to the breach of trust analysis. Mm-hmm. I think that the majority of the U.S. Supreme Court made a mistake in that analysis with respect to what it takes for tribal sovereigns to prevail on breach of trust claims. I would like to see that analysis evolve in the U.S. Supreme Court's jurisprudence beyond how it's crystallized in Arizona versus Navajo Nation. I think the majority, again, made some mistakes in the analysis. But without delving into those mistakes, the point in flagging those issues is just to say, I think tribes continue to have a really hard road to hoe, as it were, when trying to rely on the federal judiciary to prevail in breach of trust actions that are focused on water rights. Water rights-based breach of trust actions, in my estimation, based on the breach of trust analysis from Arizona versus Navajo Nation, are tough to prevail in. They are an uphill battle. I think it can be done. I know the Northern Ute have enjoyed some success in that respect over the preceding year and a half. But the federal judiciary, to my mind, is not the most hospitable forum for the realization of the trust relationship if the idea is that that realization occurs through breach of trust actions. I think they're tough. And then that brings me to the last thing. In my sense, the federal trustee should fulfill the trust relationship even more so in the policy sphere. Or strategically speaking, I would suggest that tribal sovereigns seriously consider trying to pressure the federal trustee to honor the trust relationship in the context of legislation and executive agency action that is beneficial to tribes, as opposed to resorting to the federal judiciary. There are many forms of legislation and many executive actions that can be undertaken to benefit tribal water rights, tribal water infrastructure, tribal water resources, that I think are more attainable in the policy sphere as opposed to the litigation sphere. Apologies in a sense for that long answer, but I hope at least it gets at what you asked.
It does. Thank you. One of the things I wanted to also discuss, going back to the infrastructure aspect of all of this, I was going through the Water and Tribes Initiative's work on universal access to clean water, and it really it's alarming, that in that report, we're seeing a lack of access rather to water in a lot of communities. And this goes back to kind of what you just answered, but in your mind, is this mostly an infrastructure and funding problem, or is the root of it the legal struggles over recognition of tribal water rights?
A couple big picture thoughts on that. I have colleagues who devoted their careers to this subject. Heather Tanana, a Dene colleague who's a law professor at DU, Denver University Law School, has done remarkable work in this space over the past 10 years. She's worked closely with Ann Castle, former Assistant Secretary and Federal Commissioner on the Upper Colorado River Commission, and Bito Becker with the Navajo Nation, and others. That's to say, I think there are people who are more knowledgeable on the subject than I am. As far as my knowledge goes, I think the issue is systemic.
Yeah.
I think it's systemically entrenched. I think the lack of water infrastructure, the lack of full recognition and quantification of tribal water rights are just symptoms of water colonization or water colonialism, which is a way of saying that, again, tribal sovereigns have been marginalized in decision-making over Colorado River management, governance, and Native peoples generally within mainstream U.S. culture have not been taken as seriously with respect to the human right of water as non-Native communities. In my mind, the real reason for the lack of infrastructure, the lack of prioritization of tribal water rights has to do with the society and the culture, as those things are the soil, if you will, out of which the law and the politics grow. So it's a systemic issue in my view.
Right. Thank you. I'd like to just go back and talk about maybe end the interview with ways of moving forward. How do you think we are able to move forward with all of the work that you've been doing in centering tribal nations, the needs that the tribal communities have, and then going back to a comment you made earlier about how tribes can focus on the legislative aspect of making change. In what other ways do you think that we can start to move progress forward?
My answer is a basic one. I think it's so important for people to communicate. I think it's so important for sovereigns to communicate. I think it's so important for individuals to communicate. Through communication comes understanding and visibility and empathy. And those things make all the difference in pushing our world, our shared world, into a better space, putting us on a good path for a world that's better than the one that we've inherited from our ancestors. So I think communication is really essential. To put that in the context of law and policy, I come back to what I said about governance. Dialogue over the Colorado River's management, in my view, has to be inclusive of all of the co-sovereigns. Mm-hmm. Native peoples cannot be put along the margin, as historically was the case. There needs to be a sharing of the co-sovereignty, a sharing of the decision-making authority. And I don't say that in a naive way from the ivory tower. I know it's often hard for people in power to relinquish some of that power or to share some of that power, right? But in my view, that's exactly what needs to happen. We need to move towards tripartite co-sovereignty in decision-making over the Colorado River's management. And the last thing I would say about that is, not only does that seem fair and just from the perspective of law and policy, but in my opinion, it would benefit the river itself. Why not listen to the co-sovereigns whose descendants have lived in Western North America, the Colorado River Basin, or elsewhere since time immemorial about what relationships with and over the river should look like? Not taking seriously and respecting and treating with reverence that traditional ecological knowledge is hugely problematic. Focusing exclusively on Western science and exclusively on the state and federal sovereigns, to me, is the height of arrogance. What I would like to see is tribal sovereigns involved in decision-making over the Colorado River's management, not only because that's just and fair, but because Native peoples and Native knowledge is a repository, a rich repository of relationality that would only benefit the management decisions themselves.
Great. Thank you so much, Professor. I really appreciate it. This entire conversation was great. I don't want to take up too much of your time. I really appreciate the time that you've committed to me today, as well as to the Headwaters report. I just want to end the interview by saying that the work that you've been doing is a good reminder that the law of the river is, just like you said, relational. And it gives us a roadmap on how we can create a fairer system moving forward. And I really appreciate your time today, Professor. Thank you so much for interviewing with me.
Thank you.